Hello everyone, welcome back to OpenLine. We have with us Tim Takacs, elder law attorney. We had a call from Sue right before we went to break talking about trusts.
Yeah.
So she asked a very specific question. You think trusts are one of the best creations of...
Yeah, as I said, is like one of the greatest products of the human mind.
Which I love.
And
so
in a way, I mean, it's like, oh, there's that lawyer going, yammering on again. But when you think about it is that essentially we have a law of trust that has developed over centuries, where basically you have, okay, you're a parent, you have a child who is, has cognitive impairment, maybe Down syndrome or whatever it is, and you're going, how do I make sure that, my son, who can't ever take care of himself, is going to be taken care of when I'm gone. So how can I leave that property to somebody else to hold and manage for him, and knowing that the law will protect that child? That's what a trust is. That's what a trust is for.
Nowadays, so many people, on this show, addiction is such a huge thing. You have a piece of property, and you have a child that is struggling with that, and a trust is a way to make sure that he gets the benefit of that property, but doesn't just sell it and do something bad.
Yeah, like for instance, before I was thinking about over the break is that, Sue was talking about, well, she's got property in a trust, it's for her, and then, so it protects it so she's not subject to undue influence or whatever. And I say, well, one thing it also does is that it protects the beneficiaries, because if the property is in the trust at her death, okay, it can pass outside of probate, but it can stay in the trust for the benefit of your heirs, because you don't know where your heirs are going to be and what situation they're going to be in at the time of your death. They may be just fine, but they may be disabled, incapacitated, special needs, creditor problems, bankruptcy, going through a divorce, who knows what. Addictions, all the manifold things that that can befall human beings. Where then the property could be held, that asset can be held for that, so like as you said, that child or heir could get the benefit of the trust, and it would be protected for that child, for that heir. And
the one who oversees it would be whomever that person were to designate.
Right, so Sue designates somebody and said, I think my brother should do this, or I've got sometimes it's even a sibling that can do it.
Right.
Sometimes we tend to discourage that sometimes because they're, one sibling being trustee for the other, but a lot of times in cases involving a special needs child, that's who this trustee is going to be. Is going to be, okay, I know I'm going to have to take care of my little brother, and I want my mom and dad to make sure that they put something in place, so that I can take care of him in the right way.
Fascinating. All right, let's go to Layman here. Hello, Layman.
Yes.
Go right ahead.
Thank you.
What is your question? Go ahead.
Yes, my question is, my uncle and myself names were on my deed, and my uncle died, of course, without a will, which put his siblings as heirs. And I had all of the siblings to sign a quick deed, but one that's refusing to sign.
All right.
And my question was, what actions can I take? She stated that she doesn't want anything out of it. She just is afraid to sign her name to anything.
Okay. All right, this is fascinating. I'm glad you called, Layman. Thank you.
That is really interesting.
I always love this stuff. Yes. Is this a will question? How would you characterize
Okay, so
this?
here's what happened. Here's what I think happened. So Layman and his uncle owned this property together for whatever reason. And apparently, they owned it not as joint tenants with right of survivorship, which means the last person that dies gets the property. That apparently was not Layman. Which means basically when his uncle died, then his uncle's portion, instead of going to Layman, it went to his uncle's children. So now he owns this property with his cousins. And presumably Layman has gone to all of his cousins and said, look, why don't you just give this to me? Right. Why don't you sign a deed over to me? A quick deed is what he called it, a quick claim deed. And then but apparently his one of his cousins says, no, I don't think I want to do that. Well, she doesn't have to. She owns that property.
Right.
He can't take it away from her. When her father died, he left it to her.
Now, he said there was no will. So does it automatically go to them because there was no will?
Yes.
So he didn't have a will.
Yes.
And it
so his interest in that property automatically went to his children. Presumably he was not married, otherwise some of it would have gone to his spouse. But
wow.
You know, but by operation of law, and you've heard me talk about that from time to time, is how property passes at death. One of the ways is by operation of law. You own a piece of property, you know, like Laman did with his uncle. You know, when his uncle died, his uncle didn't have a will. By operation of law, title vested in his uncle's children immediately at his death.
Right.
He didn't have, Laman, his uncle didn't have to do anything to make that happen. Just by operation of law, that happens. You know, people have been dying for centuries, owning real estate. Somehow it gets to their heirs. That's how it gets to it, by operation of law.
Right. And the operation of law is when it goes to your kids.
Yes.
So he would have had to have had a will that would have stated, it's not going to my kids. I want it to go to
Laman.
Yeah.
Or somebody
my partner
else.
Or whatever.
Right.
But now Laman's in a bit of a pickle. There are 3 kids.
Right.
And they each got a third of his half.
Yeah.
And so what does Laman need to do?
Well, Laman needs to basically, you know, obviously he can't convince, the one cousin to transfer the property to him without paying anything. He may have to write a check.
Yeah.
Because she owns that. She has a. She is what lawyers call. She has a vested right of title into that property, which she cannot be divested of.
Mm-hmm.
You know, it's not like when her while her father was alive, she only had an expectancy, because at any time before he died, he could have left it to Laman or somebody else. But once he died, immediately on his death, she had an absolute vested right in that property.
And so
we can't take it away from her.
It's interesting you think. I mean, we don't know if that person who died wanted his kids to have it, or if this is just an oversight.
Could be.
When I hear there's no will, I feel like it's just an oversight. It sounds like Laman and he may have thought, oh, this is going to just go to you when I die.
Could be.
But that's not what happened.
Apparently, because now, if the deed was drafted in such a way that it was a right of survivorship, which essentially means, at the death of the uncle, then his interest would go to Laman, or vice versa. But presumably the deed was not drafted that way. Mm-hmm. Now, I've seen some very bad drafting, so it'd be one of those things where presumably, unless if Laman has some questions about it, certainly he could, he should talk to a reasonably competent lawyer, not the one maybe that drafted it, but or maybe that's who should. Maybe that's who should look at it.
And is this a tale of why wills are important? I mean, how important are wills?
Well, what's important, is not so much about wills, is that if you own anything, then you want to make sure it goes to the persons that you want it to go to in the ways that you want it to go. Now, I don't know whether that's what Laman's uncle, maybe they were just thinking, well, we'll just use this deed, as a substitute for a will. Well, maybe that's not such a good idea. Mm-hmm. That's sort of what crosses my mind. Again, it's like a tool that if it's used properly, it could be very effective. But if misused, then it creates havoc, among your heirs.
And how hard are wills to fight? Well, I mean, how often do you see that kind of thing?
Not very often at all.
Good. Okay. Because those would be bitter, brutal battles.
They can be, yeah.
And I feel like sometimes we get calls to that effect, but they can be really tough. Good. So you don't see it a lot.
We don't, not in our office.
And a will.
And we know what happens out there, but because people mess up or,
right.
And hopefully they're not doing, hopefully it's not one of my colleagues or that's doing something like that, because our job, of course, is to make sure, it's done the right way, that, so that there's no misunderstanding that what's supposed to happen when someone passes. That's really
what it's all about.
That's really what you're trying to
Which
do.
is a gift to those who survive you.
Yes.
It's a gift. Don't leave them in a state of chaos, essentially. Help them out.
Right.
It's a gift.
It is a gift.
Because you're not around anymore, but they are.
Yes.
Let's go to Lucy. Lucy, how are you?
I am fine, thank you. I've got 2 questions. One, I just want a kind of a quick answer to, and the other one is probably going to be a little bit more complicated. First,
well, I can't promise either one.
Okay. Why can't you put use a credit union in a trust? as an account. They said credit unions say that you can't put an account over into a trust.
Okay.
You know, I somehow or some way, I may have some sort of recollection that may have happened to one of our clients. I don't know why or how, because in my view is that is an asset that is titled in somebody's name, and if you can title it in somebody's name, it means we can transfer it to a trust.
That's what I thought.
That may be some sort of policy, or maybe some weird thing where you get the wrong person that they don't know what a trust is, and so they think the safest course is to say no, you can't do this.
Yeah, because you know that's scary if you have an account at a credit union and you have your important papers, say, in a safe deposit box.
Yeah.
And you're the trustee. Now you can't go get those assets out of that credit union or that safe deposit box because it never transferred over into the trust.
Yeah.
You're kind of SOL, as they say.
Yeah.
You know, it could cause some serious problems if all the legal documents are in that. So anyway,
now,
well, here's my serious question.
Okay, Lucy.
I mean,
Lucy,
not that's not.
Lucy, hold your serious question, because I have a comment about the safe deposit box.
Okay.
Before I forget it.
Okay.
Don't put important papers in a safe deposit box.
Why?
They do not have street value.
Now, what does that mean? What do you
That
mean?
means they're not like gold or jewelry or diamonds. They can be replaced. What's most important is that they be accessible when you need them.
I understand that, but you know we live in Tornado Alley.
Right.
What do you do? Honey, grab the wheel. We're getting ready to go under the ground.
It's actually
a tornado. I mean, how do you protect that?
Surprisingly, it's not as difficult as you think that people will accept copies. Believe it or not.
If you're incapacitated, how does anybody know that you have quote unquote papers?
Well, if you're doing this the right way, you know, like if I'm doing a document, you know, I'm going to make sure that the people that I've named as my power of attorney, you know, have a copy of it, or at least know where to find it.
Well, that's correct. Well, I've stumbled across somebody's computer at the moment I needed to find out that they had that set up, and the lawyer's name was in that computer. If I had
that's good.
They would have been in some trouble.
Yeah.
But my second question, and if you have to take a break, you can answer it after the break or whatnot. But my second question is about trust.
Yes.
Okay, you talk about how secure like a revocable trust is. When somebody dies, it becomes irrevocable.
Right.
But here's my question. Say a trust has to be set up with a will, correct?
Usually we use a will with it as well.
Okay. All right. Say you just have a will.
Yes.
The will goes through probate and it can be challenged. Say there's two siblings, okay?
Right.
One of the siblings says, I don't like how that will is written. I'm going to challenge this will and milk this estate dry because I'm angry.
Right.
My question is, if you have a trust, you take the further step, can they milk that estate to death by lawyering up and draining the account down because they're mad because mother gave you the antique roadster? You know what I'm saying?
Oh, sure.
Okay, thank you, Lucy.
Yes, and that's true. I mean, because, now, anything, you know, like sometimes we say is, you know, anybody with $300, you know, for a filing fee can go down to the court and file a lawsuit.
Right. Yeah.
You don't need to have a lawyer to do that. You know, now, judges are wise to that. You know, they know that, you know, certainly if you've got a trust set up and instead of that's not something that needs to go public if it's a trust. But if somebody doesn't like what you did, you know, then they know where the courthouse is. But they have to hire their own lawyer, because I'm going to assure you that, you know, if I'm a disgruntled heir and I think I should get more and I go to see Tim Takacs or some other lawyer, you know, Tim Takacs is going to say, well, I'm going to need an X number of thousands of dollars retainer. You know, it's not cheap, you know, and don't expect to get it out of the estate. You know, I'm not waiting for my fee. You know, this is not my case, it's your case, so you're going to pay me whether you win or lose. You know, and that's part of it is as well. But if he wants to go and file his own lawsuit, you know, the judges will figure that one out.
Interesting.
Yeah.
Okay, Lucy, thank you. Thank you for that call.
It was. Good call.
If you want to call in, there's the number, 615-737-PLUS, 615-737-7587. We'll take a break. Be back right after this.